Hello, and welcome to the third session of the DC Bar Pro Bono Center's four-part webinar series in partnership with Steptoe, Protecting Your Innovation. This session will cover trademark and copyright. I'm Christine Kulumani, staff attorney with the DC Bar Pro Bono Center's nonprofit and small business legal assistance programs. First, thank you to my colleague Lauren Paley, who is our webinar and get everything done behind the scenes guru and all of the work that she has put into this. Also, a huge thank you to our experts and presenters from Steptoe, Kate and Lee. On July 7th, Kate and Lee kicked off this series covering the basics of IP. During our second session on July 21st, they dove into patents. And again, for today's session, we'll go through trademark and copyright. The final session in 2 weeks on August 18th, we'll discuss trade secrets. Before we get started, a reminder about the logistics for the webinar. If you're watching this live, the webinar will be recorded. To access the recording, please complete the survey that we will email to you after the webinar. In addition, you have immediate access to the presentation slides right now in the Handouts tab of the GoToWebinar control panel. If you have questions, please send them to us through the questions box in the control panel. We'll address as many appropriate questions as we're able to today. On to trademark and copyright. These are areas of intellectual property that really have the potential to be important to every organization. The organization's name, logo, slogan, colors, smells, and more may qualify for protection under copyright. Under trademark, copyright law may protect curriculum, presentations, blog posts, photographs, videos, and much more. Understanding these protections not only helps identify if your small business or nonprofit can benefit from these protections that may be offered, but also to make sure that you steer clear of infringing on the trademark or copyright rights of another. That can be a headache, very expensive, and it can do some really big damage to the reputation of your business. And with that, I am going to hand it over to Lee to get us started. Thank you.
Thank you very much, Christine. Thank you, Lauren. And thanks to the DC Bar for organizing this event. Thanks for everyone to being here. My name is Li Guo. My colleague Kate Kevin and I will discuss trademarks and copyrights with you today. Before we start, just a very quick disclaimer that we're here to provide information but not to provide legal advice, and we're here on our personal capacity, not on behalf of the law firm. And I will talk about trademarks. So what is a trademark? The easiest way to think about a trademark is that it is a brand for goods and services. Technically, they are like two terms, trademark and service mark. A trademark identifies the source of goods, while a service mark identifies the provider of a service. But usually the term trademark is used to describe both categories, and we will use the term trademark for both in this presentation. So in addition to identifying the source, a trademark can also provide legal protection of your brand and help you guide against counterfeiting and fraud. A trademark can be a lot of things. For example, it can be any word, phrase, symbol, design, or combination of these things. We see trademark a lot in our everyday life. For example, most of the drinks we drink, the food or the restaurant, the clothing, and they all have trademarks on it. Trademark is a very important part of every business. And for example, we use computers like Apple, like iPhone or iPod. Those are trademarks. Like you see here, the McDonald's, the Golden Archer is a trademark, and the word Nike is a trademark. Also, like the swoosh is also a trademark. And for the social media, like Twitter or the search engine you use, Google, those are also trademarks. And another example on this slide is Coca-Cola. That is a trademark. It's a good example of using trademark to identify the source of the goods, because if you want a, Coca-Cola, you don't get a Pepsi, or if you want a Pepsi, you don't get Coca-Cola, because those words are used to identify the source of the beverage. There are also other types of trademarks. I think like Christine mentioned a few. It can also be like a sound, a color, a scent, or motion. So trademarks don't have to be just words or logos. An example of a scent trademark is showing on this slide. It's actually a Play-Doh scent trademark. Uh, and I'll also give you an example of a color trademark. For example, we've seen like the UPS brown color truck everywhere, and that's a trademark. A sound trademark, we also know a lot of those. For example, the Intel jingle we hear. For the motion trademark, one example is that you see the lighting effect that rotate around like the microphone when you use the Siri. That is actually a motion trademark. So it's also important to understand that not everything you want to register as a trademark can be registered. The word or symbol that you want to use as a trademark must be distinctive to be registered as a trademark. There are several different categories of trademarks you can put them into for different level of distinctiveness. The strongest marks here are on the top. They're called fanciful marks. So for these trademarks, the words are invented. Like they didn't exist. You invented the words, and they have no other meaning apart from the association with the goods or service you're providing. For example, I have here on the slide like a Kodak or Starbucks or Exxon or Xerox. Those are all fanciful trademarks. The next category of a trademark is called arbitrary trademark. They are familiar words, but they're used in connection with unrelated products or services. I mean, one example we all know is that we use Apple for computers, while computers, have nothing to do with Apple, and we use like Monster for job searching. That's also a fanciful trademark. The next level is suggestive trademarks. These trademarks are not as distinctive as the first two categories, but they may still be considered strong marks. A suggestive mark usually hints at some function or property of the product or service, but does not describe it directly. Some example of the suggestive marks is that like Airbus is used for airplanes, or Greyhound is used for bus services. Oh, let me go back. The next category of the trademark is called descriptive marks. They are not as strong as the first three categories. Usually it's a word or design that directly describes the product or service. For example, you want to call the yogurt you're selling creamy yogurt, and it's only registrable after the word or the symbol gains distinctiveness through extensive use in commerce for years. Last category is called generic trademarks. Actually, they're not trademarks because you cannot trademark generic terms. These terms are everyday names for the goods or services. Because of that, they do not indicate the source of the goods or services, and therefore cannot function as trademarks, and they cannot be registered. For example, you cannot register the name bicycle for a bicycle shop. So before you choose your trademark, it is important to do a searching to avoid using a mark similar to the ones that other people already used. You can do some preliminary search by yourself. And if you want to have a more thorough search, you can go through an attorney. First place to search is the USPTO, the Federal Trademark Register database. And this database has all the federally registered trademarks and applied for marks. It is also available on the USPTO website. You can search there for free. The name of the system is called a Trademark Electronic Search System. In addition to the search in the USPTO database, you should also do additional searches because the USPTO database only has the federally registered trademarks. The other sources you can search include the state trademark registry database and also like business name directories, domain name registries, like media database, like industry specific sources. And also if you think that you may plan to use a mark outside of the US, you probably can also think of doing some foreign availability searching, especially in the country that you think you're likely going to do business. And one question people often ask is whether you can do the search by yourself or whether you should hire an attorney to do the search. You can start doing the search by yourself, for example, in the USPTO database and do like online searches. If you do want a more thorough search, you can hire an attorney to do that. So the other question people often ask is, do you have to register your trademark? And the answer to that is no. You don't have to register your mark to have it as a trademark, because trademark rights are created through the use of your mark in the commerce. It's not through registration. Like the use-based trademarks, if not registered, they're often called common law rights. The common law rights do have limitations in comparing to the federally registered trademarks because they're often limited to a particular geographic area, and they're not in the database, so it's less likely for people to know about it. It's also maybe difficult for you to enforce those trademark rights outside of the limited scope of the area. So even though federal registration is not required for trademark protection, it is strongly recommended to have a federally registered trademark because it provides very important benefits. And we're going to look at a few of those benefits in the next slide here. So first, it gives you a legal presumption of the exclusive right to use your mark like nationwide with the goods and services that are identified in your registration. It also creates a legal presumption that you are the owner of the mark. Otherwise, if you want to enforce your trademark in a court, you may have to prove that you are the owner of the mark. And additionally, it puts the public on notice because it is published and it is in the federally registered database. So when other people try to register trademark, they can avoid using a mark that's too similar to yours. You can also register your mark with the U.S. Customs and Border Protection to identify and stop counterfeiting goods from coming into the country. But typically, the CBP, they can put your registered mark into the database, and they will inspect like the shipments and compare that to the database to see if they're infringing trademarks, and if so, they can notify you of the suspicious products. There are also other benefits having a federally registered trademark. For example, you can file lawsuit in federal courts, and also you can use that as a basis to file for a trademark application in foreign countries. And it becomes eligible for incontestability after 5 years. Very importantly, you are able to use this R in the circle on your products. There are two different bases you can use to file for trademark application. One is you use the mark already in the commerce. Two, if you haven't used it yet, but you intend to use the trademark very soon in the near future, you can also file for a trademark application. If it is already being used in commerce, the basis of the filing will be on the use basis. And you will list, so in the application, you will list, for example, the date of the first use of the mark, and also you will need to submit a specimen of the use of the mark. If you have not used your trademark in commerce yet, but will use it in the future very soon, you can file an application to register your trademark under this intent to use basis. And if your application meets the examination requirement, you will receive a notice of allowance. However, to register your mark, you still have to show the actual use of it before the mark can be registered in the database. So in many cases, like for business, like you may want to start the trademark application as soon as after your company is incorporated. By filing such an application before your product is launched, you can be sure that your name is protected before you spend a lot of money to plan for the commercial sales. Otherwise, if you register after you already have your everything ready, and it turns out someone else was already using the same mark or very similar mark, you may have to you may have to spend a lot of more money to remove the previous mark and to relabel all your products. Another benefit of filing an intent to use application is that you can get an earlier filing date than a potential competitor, assuming the mark, if it's a very good one, and that a competitor may also want to file a trademark for it. By filing earlier, you will get an earlier filing date of the trademark. So this slide shows the basic process for trademark application and registration. You can file your application and related documents online, and after that, examiner attorney at the USPTO will examine your trademark. If the examination process finds like nothing wrong with your application, and it will be the mark will be published, and if nobody opposes the mark, it will be registered. So after that, you can just renew your mark every 10 years and show that you're still using the mark. And another question people often ask is, do you need an attorney to help you file a trademark application? Of course, an attorney will provide certain benefits because they're very experienced in the process. And if the PTO issues a refusal to register, they can help you respond to that action, or if anybody files an opposition to your trademark, they can also help you prepare a response to that. But on the other side, it could be expensive to have an attorney to do your trademark filing and registration. There are pro bono resources that you can look for to help you with the process. If like your company is small and has a limited budget, the USPTO website also has very detailed information about how to apply for the trademark and the process of doing that. And I think DC Bar has a very good program on that too, and other bar program in different states could also have a pro bono program that can help you to navigate through the trademark application process. So if an examiner issues what we call like an office action to reject your trademark application, it can be for a number of different reasons. One very common reason for refusal to register your trademark is called likelihood of confusion. And the main things considered in this refusal is that there are other marks that are similar to your marks and used in related goods or services. For the examiner to find a likelihood of confusion, it is not required that the marks and the goods or services be exactly the same. And usually if it's similar enough and if the goods and the services are related, it could be a sufficient reason for the examiner to refuse to register the trademark. Of course, there are also other reasons the examiner may reject the registration. For example, if the trademark is merely descriptive or deceptively descriptive, and if it's like geographically descriptive and geographically deceptive, misdescriptive, Other reasons also include that you cannot register trademarks that are scandalous, disparaging, or immoral. Additionally, any name, portrait, or signature of a living individual or deceased president cannot be registered as trademark, or the same for surname. So after you have the trademark rights, let me go back one slide. So after you have the trademark rights, there are typically two types of trademark rights. One is the common law trademark rights, which is typically obtained simply by using the mark in your business with a product. You can use TM for the common law trademark rights. And if you registered your trademark at the PTO, you have the right for exclusive use nationwide, and you can use the R symbol. So for example, if you have only common law trademark rights, or if you only have state law trademark rights, and then if you move your business to a different location, you may need to register your trademark again with the different state, because state trademark law only applies to the state. But if you have like a federally registered trademark, since it gives you the right of exclusive use nationwide, so even if you move to different state, you don't have to register it again. And another question is, if you want to apply for trademarks in other countries, is there a protocol to do that? The answer is yes. There's this treaty called the Madrid Protocol. You can apply for trademarks through the PTO in other countries. So the basic procedure is that first of all, you have to have an application with the PTO, which is called the basic mark. And then based on the basic mark at the US PTO, you can file an international application at the patent office, which will then forward the application to the WIPO. WIPO is a Worldwide Intellectual Property Office. So WIPO will check the formal requirement. It only checks like the form. So it does not do substantive examination. So if the form requirement meets the criteria, it will be approved, and WIPO will issue a certificate of international registration to you. Because if you want to file for the international application, you have to choose the countries where you want to register. And after the WIPO issues the certificate, it will notify the countries that you wanted to register. And each country will examine your trademark based on the law of that country. They can either accept or reject the mark based on the law in the country. And if it's registered, you will receive a statement of grant of protection from the foreign country. So after you have a trademark, make sure that to monitor your trademark, and if other people are filing for registration of similar marks, you can file an opposition to that, and you can also register your mark with the U.S. Customs and the Border Protection, as we previously discussed. If people are using a trademark that's confusingly similar to yours, you can send them cease and desist letters. Also, if that won't stop, you can file a trademark infringement litigation in court. So for trademark infringement action, this slide just lists the typical factors a court would consider to find trademark infringement. The two most important ones are similarity of the marks and the relatedness of the goods and services, because as we know, the same marks can be used on different goods or services. For example, you have like a Delta airline, you can also have like Delta dental insurance, even though they're the same trademarks, because they're used on unrelated goods or services, that's fine. So in addition to those two factors, the court will also look at some of the other factors to determine whether there is trademark infringement. In addition to trademark infringement, there's another action called trademark dilution. So to find liability of trademark dilution, you have to own a famous mark that's distinctiveness. And the defendant's use of the mark diluted your famous mark, and also the use began after your mark became famous. So because of the use, like your famous mark is likely to be diluted. And there are several online tools you can use and look at if you want to learn more about the procedure, if you want to think about whether to do the application by yourself. All of these tools on the USPTO's website. The first one is the database where you can do the search. It's called Trademark Electronic Search System. And to file a trademark application, it uses a system called Trademark Electronic Application System. And after you filed the application, you can also check the status of your application by looking at the trademark status and document retrieval system. The other document is very important. It's called a listing of acceptable identifications of goods or services. Since if you apply for a trademark, you have to choose which category of goods or services your trademark is for. And the last one, it has it's called a trademark manual of examining procedure. So this has everything the examiner will look at and all the basis of the rejection the examiner may issue and all the other procedural aspects of the examination process. Okay, just to have a quick summary, I make sure first of all to choose a strong mark and then before you apply for the trademark, do a trademark search. So then register your mark with a PTO. Make sure to police your trademark and think about international registration if you are planning to do business outside of the US, and renew and maintain your mark if you keep using it. I think that's the last slide of my section. Christine, if there's any question I can help answer, let me know.
Thanks, Lee. Yes, we have a few questions. First of all, if a business or nonprofit selects a name or a logo and they don't plan to file for federal trademark protection, but just rely on common law protections, would they still need to perform a trademark search to see if anybody else had the same similar name or logo?
I would think so, because if you don't do a search now and if you're only using the mark on your goods and products, because after your products become famous, somebody else who already has a trademark can send a letter to you or can sue you saying, hey, I already have a federally registered trademark before your use in the commerce, therefore you have to stop using that trademark. Actually, there's a recent example I just saw the other day, that we all know that the Easy Shoes by Kanye West, he didn't have a trademark for the logo that he used for the shoe, and I think Walmart is suing him and saying his logo of the shoe is very similar to the logo of the Walmart. I don't know like how the case is going to go, but to avoid like troubles like this, it's even if you don't register for it, I think it's still a very good idea to search the database to make sure that like a similar mark was not already used on similar products before you.
Okay. In order for a business to file an infringement case or file an opposition for somebody else's registered trademark under maybe intent to use, is there a certain threshold level of evidence that they need for a business? So for example, would there need to be a certain presentation of evidence about why it was likely to cause confusion or how it's too similar? Or is this really something that is up to the judge?
you do need to present some evidence if you want to file, for example, a lawsuit at a court. There's like a what people call a pleading standard. You need to present a sufficient like factual allegations to support your infringement claim. In the trademark situation, for example, trademark infringement, you will need to show that your mark and the defendant's mark you're suing are similar, and also like the product your mark protects and the defendant's products they're selling under the mark are also related, because even though you don't have to prove your entire case at the beginning, but there is some threshold requirement to file a lawsuit in the federal court.
Okay. Would it be sufficient infringement of a trademark if another organization simply incorporated under the same or a similar name, even if they were not operating under that name?
Okay, so if I understand it right, that the trademark and the name of the corporation do not have to be the same. Usually people do trademark, use like their corporate name as a trademark, probably for convenience. But your corporate name does not have to be a trademark if you don't use your corporate name as identification of the source of the goods. So so it could be different, and if they're using your mark to identify as a source identifier, I think that could be a basis of a trademark infringement lawsuit.
Okay.
If I understand it right.
No, that sounds exactly
Okay.
spot on. So you had mentioned that a business may benefit from federal registration or filing an intent to use application after incorporation before they really get going to help protect them. If there are new classes of use or new trademarks that come up during the course of business, is there a good time for when to file for those?
I think it's probably answer would be similar to file it as soon as possible, because even if like you have a trademark that protects one area of the goods or services, but if somebody else wants to file a trademark, a similar trademark, but protect a different classes of goods or services, the PTO may allow it, since if the goods and services are not related, they do allow the same marks to be used by different people. So yeah, I think it's probably also a good idea to file it as soon as you realize that you want to use the mark for a different class of goods or services.
All right, perfect. Thank you, Lee. And I think
Thank you.
now we will turn to Kate for copyright.
Thank you, Christine.
Thank you very much, Christine. So copyrights, talking a little bit about copyrights. Just give me a second, my computer is not, there we go. So copyrights are in the Constitution, Article 1, Section 8, Clause 8, to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. This was implemented, kind of skipping ahead for a minute, there's the copyright clause. It's also implemented in federal law under the Copyright Act. So copyright protection subsists in original works of authorship fixed in any tangible medium of expression. We'll talk a little bit about what that means. There's also copyright that's covered under state law. It's fairly limited and you can't really double dip, so you can't bring both federal and state law copyright claims. In terms of the Copyright Act, though, the Copyright Act is administered by the Library of Congress. It's the main U.S. agency who is responsible for administering the Copyright Acts. It's headed by the Register of Copyrights. There are also 4 associate registers. There's 8 divisions, over 400 employees. And the Library of Congress does a lot. So they've processed over 444,000 claims, recorded over 250,000 titles. So a lot of works have been copyrighted, and the Copyright Office handles, or the Library of Congress handles, quite a bit. Under federal copyright law, as I said, it kind of lays out that copyright protection subsists in original works of authorship, so keyword there, original and work of authorship, and then fixed in any tangible medium of expression. So what does that mean? Original, it has to be independently created by a human author without copying. Work of authorship, it means that there has to be a minimal degree of creativity required, and we'll talk a little bit about that. And also fixed in a tangible medium of expression. It has to be captured in a sufficiently permanent form to allow for viewing, copying, or communicating for more than a short time. So what is a work of authorship? A work of authorship is an independent creation. It has to be creative. So it's not a high bar, but there needs to be some modicum of creativity. What does that mean? If you have a simple geometric shape, a short phrase or slogan, a simple listing of ingredients without anything more than a listing of flour, sugar, butter, contents, things that are contained in something, fonts, so a certain color of text, a certain style of text, that's not really considered to be creative per se, and so that wouldn't be considered to be a work of authorship. The intent isn't important. So even if you think that you came up with the greatest font in the world and it's really pretty and it has great color and you spend a lot of time on it, the Library of Congress and the Copyright Office isn't going to give you a copyright for it. So the amount of effort that you put into it, I guess, isn't necessarily something to consider. It's more just kind of, is it more than just what would be considered under the Copyright Act to be a more general or basic, simple shape, font, text, etc. The other real key component is what is fixed. So the work has to be recorded or written down in some manner and for a long enough period of time. In general, most works are fixed because they exist in some sort of reproducible form. Something that would be unfixed, if you're giving a business presentation and there are no PowerPoint slides, nobody writes anything down, it's not recorded, and at the end of the day, everybody goes on their way, that isn't considered to be fixed. That would be unfixed. Similarly, if you give an impromptu speech off the cuff, you don't have any notes written down, nobody records it, that would be unfixed. What is important though is, so your right is in the actual work. So if you have a speech that is fixed, so you write it down, there's notes on it, etc. The speech itself is what is copyrightable, not the actual notes, the physical item that is fixing them per se. It is more the actual text of the speech and the words of the speech that would be copyrightable. So what can be copyrights? A lot of things. Many things can be copyrights. So copyrights can be literary. What does that mean? They can be novels, newsletters, works of nonfiction, poems, software can be considered to be a literary copyright. Dramatic, so you can have plays that are copyrightable. Musical songs can be copyrightable. Pantomimes and choreographic works, dance routines, if they're recorded or written down in some sort of fashion, those are copyrightable. Pictorial, graphic, and sculptural works. So sculptures, paintings, photos, all copyrighted, all copyrightable. Motion picture and other audiovisual works, so movies, TV shows, video games, specific recordings, Architectural work, so architectural drawings, maps, things like that can also be copyrightable. Examples that come up a decent amount in the business context, for example, would be promotional materials. If you put together materials for something, a project that you're working on, or for your company, a pamphlet, a newsletter that you send out, that can be copyrighted. Ads and commercials that you put together, training materials. So if you're conducting a training, if you have an HR guide, anything like that, that can be copyrightable. Presentations that you put together, studies, architectural plans, software. So if somebody asks you to put together a presentation, this presentation could be copyrightable. Materials that are on websites are also subject to copyright. So it's fixed, it's a work of authorship, you put it together, that's also copyrighted. So those are kind of some context that you see it in terms of business. And at the end of the day, it's a lot of things. A lot of things fall under copyright. We'll talk a little bit about what may not, and how to go through that, but most things can be copyrightable. So for example, if you are taking notes right now, probably can have a copyright on those. If you're doodling right now and not taking notes, also copyrightable. So again, it's a pretty broad scope of things. I'm not saying that you should try to register for a copyright on the notes or doodles, but if that gives you an idea of kind of the scope of how broad copyright is, it's pretty broad. So what can you do if you have a copyright? Copyright law provides an owner of a copyright with exclusive rights to reproduce that work. You can make copies of it. If you have a newsletter, for example, you can reproduce that newsletter. Website, you can put it up online. Photo, you're allowed to reproduce the photograph. You can create derivative works. So you can take your original work, modify it slightly, change it slightly, and create a derivative work based off of that. You can distribute it. So you can give it away to others. You can grant licenses to it. So you can take money or other forms of payment in return for allowing somebody else to use your work. You can transfer ownership, so you can give all of your rights in something to somebody else. You can lend it, you can give it for a short period of time. You have the right to publicly perform. So if you write a play, having a copyright on it means that you have the ability to perform it wherever you want to. Photographs, you can publicly display them. And again, it also just gives you the ability to allow others, through whatever form you want to exercise any of these exclusive rights. Copyright protection lasts for a very long time. It's the life of the author plus 70 years after the author's death. If you have a key author, if you have works made for hire, or if it's anonymous, 95 years from publication or 120 years from creation, whichever is shorter. We'll talk a little bit about works made for hire and what that includes. After the copyright expires, so after for example, the life of the author plus 70 years after the author's death, what happens? The work is in the public domain, so it can be used by anyone without penalty for any purpose. So you can reproduce it, you can publicly perform it, you can do what you want to do without having to worry about having somebody say that you're infringing on their copyright or suing you. So we talked, copyrights are a lot of things, right? What aren't copyrights? Again, they're not basic ideas. They're not discoveries or principles or basic methods of operation. A way to think about it is there are also things that aren't kind of utilitarian in nature. So for example, while you may think clothing patterns, designs on clothing are a very interesting, you may have a really cool pattern that you've come up with, but clothing is utilitarian in nature. So courts have frequently held that the design of clothing itself or the design on clothing, you cannot protect that by copyright. There may be some exceptions to that, but in general, if there's kind of a utilitarian nature or aspect of it, you may not be able to get a copyright on it. And just general discoveries if you find something that's not copyrightable. Copyright owners can fall normally into a couple of different categories. One is the author of the work. So that's a pretty straightforward one. If you're the one who wrote the novel or took the photograph, you may be the author of the work. There's also works made for hire. So works made for hire are often created by employees in the course of regular duties or by express written agreement. And so in that case, the owner may be the employer or the person who actually commissioned the work, who asked you, and you have some sort of written agreement that you're going to create some product for this other person. In that case, if you have agreed you are creating, let's say, a website for somebody else, you are likely not going to be the owner of the website. The person who asked you to create it will be, and they would be the owner of the copyright then. Similarly, if you work for a company and you create, let's go with training manuals as part of your job description, as part of your daily duties, you put together all of the job manuals. Those manuals could be copyrighted, but you are likely not the owner. There is probably something in your agreement, your employment agreement, that says that it's the company who is the owner of this. So just kind of something to keep in mind. And that, again, like assignments in writing. So if you do freelance work, for example, or you're a freelance photographer and you assign the rights in a photograph to somebody else to use on their website, for example, in marketing materials, then the ownership may transfer, and it would be the person who was assigned the right in that who has ownership. So this is some examples of work made for hire and assignment. So under work made for hire, if you're the in-house graphics department that develops creative logos, posters, promotional materials, that's something that would your employer is likely going to be the owner, even though the graphics department developed the actual copyrightable material. So again, the employees who write business documents, HR employees who develop written processes or protocols for how things are going to be done. Assignment, kind of like we talked about, visual artists, freelancers who assign rights in photographs or drawings, independent contractors who assign rights in works like software packages or web design. Those are kind of different categories. Most things with ownership fall into one of those two when it comes to copywriting, taking aside the more straightforward one, which is just you wrote the document as an author, like if you write the book, etc. That's kind of a different beast. So what if you're not a copyright owner? So you don't fall into one of those categories, but you want to be able to use the copyrighted work. You can license it or try to seek an assignment. Licenses, and we'll talk about, they're everywhere. And so licensing is something that is very common in copywriting. And if you know somebody who has a work, you may be able to reach out to them, or you may have already done it or agreed to it without having to explicitly reach out to them. There's also fair use. So fair use is the general idea that brief excerpts of documents can be quoted verbatim for certain purposes. So there's a couple of things, or four things really, that are considered when you're contemplating fair use. The purpose of what you're using the quoted information for, the nature of the use, the amount that's used, and the effect on the market. So purpose, are you using the copyrighted material in a commercial sense? Are you trying to monetize it or get some sort of gain? Or is it an educational sense, a transformative sense, or an illustrative sense. So for example, if you are using it, an excerpt of an advertisement or a photograph from a magazine in a lecture, or to talk about other cultural issues that were occurring the year that that photograph was taken, that may fall under fair use. And so you may not have any sort of copyright issues. What's the nature of it? Is there something, how are you using the material? You can criticize it. You can use it for news reporting, teaching, research. Those are all areas where you may have more leeway to use the material. Also, how much are you using? Is it something where you are quoting a sentence or one picture, or do you have the entirety of a novel and you are reproducing that on your website? If it's the latter, you're probably going to run into some copyright issues. If you have one sentence and you're talking about it in a context that is not the purpose of the book, then you may be able to qualify under fair use and not have any sort of copyright infringement issues. And one of the key ones is, what's the effect on the market? And the way to think about this is, what is your purpose really in using it? With the example I just gave, if you have a book or somebody writes a book and you take the entirety of the book, or almost the entirety of the book, and you put it on your website and you say, hey, so-and-so, pay me for this, or don't pay me for this, I've just reproduced it for free, so now you have access to it, you are taking away proceeds that the other individual who wrote the book would have received from that work. So you are affecting the market and hurting the rights of the actual copyright owner, especially because you're using it in a very similar way to what the actual rights holder would have been using it as. So that being said, those four categories, purpose, nature, amount used, and effect on market, are considered under fair use and often give you ways that you can use portions of copyrighted materials or avenues to use copyrighted materials without worrying about copyright infringement issues. There's also the first sale doctrine. That basically means if you purchased something, or if you were if you buy a book, you can do what you want to with that book to a point. You can't then make copies of that book and go off and sell it on your own. So there's no right to reproduce, but you are able to, you can put that book in your window if you want to. You can use the materials in that book as you want to. You can look at libraries and archives, and you can, a lot of times, if you're not a copyright owner, you can see what's already in the public domain. So the public domain is anything that's not covered by copyright law, things that are expired. So your older works, older plays, older books, for example, that have expired and are no longer covered by copyright law. Things, again, that are insufficiently creative. So your generic images, short slogans, things like that, that you would be able to use because they wouldn't be covered by copyright. Licensing, as we talked about, licensing is everywhere. Think about it in terms of like office software. You have a license to use that software. You probably clicked through it at some point, but I guarantee if you are using Microsoft Office, for example, you have a license to a copyrighted work. Music that's used in presentations or in bars and restaurants is often considered to be licensing. In terms of business uses, you can resell physical items, reprint government works, again, using simple shapes, phrases, etc. So there are a lot of kind of non-owner business uses that you can do without running into copyright issues. So how do you get a copyright? Well, You don't actually have to register. You can just have one. So you could have a copyright on the doodle that you're creating right now. It's voluntary to actually seek protection, but it's generally recommended that if you are doing more than, let's say, just doodling, if you have a book, if you have some sort of process that you, or photographs, et cetera, that you really want to be able to monetize, you should seek copyright protection from the Copyright Office in the Library of Congress. And one of the reasons of that is that you can't go to court without trying to register a US work. And key there is trying. You can go to court if you try to get a copyright on something and are denied, and the Copyright Office says, no, that's not copyrightable. You can still go to court on that. But you need to have at least attempted to get a copyright on it before you can bring a lawsuit. But above and beyond just the ability to go to court, if you register your copyright, you can get damages and attorney's fees. You're not able to actually get damages unless you have registered a copyright. There's also certain presumptions on that facts on the certificate are correct. So you won't necessarily, if it's a copyright date, for example, or copyright information about what's covered, there's less disputed things if you have a certificate saying that your copyright is registered. It also helps get you in touch with potential licensees. Again, a way to monetize what you're working on. If you have a copyright out there, then others can reach out to you and say, hey, I saw that you did this. Can I license it? I'm really interested in it. And as a way for you to kind of build business and generate business, it lets others know about your claims and it helps the public at large. The more kind of think of it as the Library of Congress has, I don't know if you've ever been there, but it has one copy of everything that's ever really been copyrighted. So there's a lot of information there that the public has access to simply because people have filed and registered their copyrights. How do you register? The Copyright Office online can walk you through it. There's different types of applications. Depending on the type of work that you are trying to register, you have to make sure that you're doing the right application. You have to provide an actual copy of the work or the work itself, depending on what type of work it is. And a fee that depends on the work and the type of work and number. So all of this is outlined on the Copyright Office website, which is really the best place to go to in terms of figuring out how to register your copyright. But there are different ways you can do it. You can do it one work at a time. You can do it by group. And if you're doing groups, there can be different types of doing it, whether they're unpublished photographs, unpublished works, contributions to magazines. If you're planning on registering your copyright, the best place to look is probably the Copyright Office website itself, and that will really walk you through it. Registration itself doesn't necessarily take that long compared to how long it takes to get certain things. Patents, for example, take far longer. But there may be correspondence back and forth with the office asking you questions about the copyright. If there isn't, and you file online, you can generally get a registered copyright somewhere between 1 and 6 months, average of 3 months. Mail takes a bit longer, as everything seems to do if you're doing it by mail. And if you have correspondence, average is again 6 months, so about double the amount of time, but generally still within a year. And if you're doing mail and you're going back and forth with mail correspondence, it may take longer, but still within 2 years that you should have something. This last slide is just some resources that you can look at on trademarks. And for the Copyright Office, if you look at the Copyright Office website itself, it has a lot of information on registering and how to register. I know we are out of time, and that's actually all that I had on copyrights. I don't know if we have time for questions. I'm happy to answer any if we do.
Yeah, I know that both of you are super busy, so we have a couple of questions that are of the same category that we may be able to kind of get through quickly. So would a curriculum or guide, that's drafted by an author based on their education, they're just, putting the information they process into another form, might that be sufficiently creative for copyright protection?
Yeah, I think so, potentially. I mean, if it's based on your education and you're putting it into another form, and it could be viewed as notes or summarization, et cetera, kind of repackaging, then I think that could be copyrightable.
Okay. We've had several questions about, and you talked a bit about, copywriting a recipe. So if there's a recipe or a cookbook that's copyrighted, does that prevent somebody else from using a recipe with those same ingredients in the same quantities, in the same order, in their own cookbook or their own website and recipe? Or does it only protect that exact writing of 1/2 cup of flour and the next line below, 2/3 of a cup of sugar?
So the ingredients themselves in that list are not copyrightable. It's kind of what you do with it then, and what happens next.
Okay.
So the recipe itself is likely not protected. The physical, here are the ingredients that need to be added. But if you are taking it, transforming it, adding more to it, then you may have some sort of level of creativity. For example, if there are additional steps or processes above and beyond just the list of ingredients add together, that may be subject to more copyright.
Okay. We talked that photos, videos, blog posts, words that are creatively written can be copyrightable. Does that also apply to things posted on social media, like a caption on a tweet or a picture that you took and posted on Instagram?
So I will say that I am not completely well versed in how everyone is ruling on this, but yes, I think that to some extent, if it is fixed in a form and is written down in social media, even if it's not like, for example, like a Snapchat or something like that that's going to disappear, then if it's fixed and is written, then you could argue that there is some sort of copyrightable material related to that, yes.
Perfect. And just one last question. When an author or the creator of a copyrightable work goes to file it, is there any type of vetting done to make sure that it doesn't infringe on another registered copyright, or is it an honor system?
So I am not 100% sure. I think that there is some sort of generally speaking, I think that the Copyright Office does do internal vetting and does check to see what you're filing, which is why you may have correspondence back and forth. So for example, if somebody wrote, but obviously Dickens died a long time ago, but if you had Great Expectations and somebody took Great Expectations and tried to resubmit it to the Copyright Office, I think the Copyright Office would come back. I don't know the level of work that goes into it, but yes, there is processing and back and forth with the Copyright Office on that.
Amazing. Thank you. And thank you to Lee also. And thank you to everyone that joined us today. Again, we will send out a survey, so please share your thoughts on this webinar and any topics you're interested for future webinars. And once you complete that, you will also get access to the recording of today's program. We hope that you'll join us along with Kate and Lee on August 18th for the final session of this series, where we will close out by talking about trade secrets. And please remember, If you would like to chat one-on-one with an attorney for free about your organization's legal questions, view the Pro Bono Center's upcoming events, or take a peek at our online resource library, you can visit us at lawhelp.org/DC/NPSB, lawhelp.org/DC/NPSB. And that stands for Nonprofit Small Business. Thank you again to Lee, to Kate, and to the Steptoe team for helping us get through this series and for a fantastic presentation today.